If parents are unable to care for their children, or just don't want the grandparents to have much, if any, contact with their children, do grandparents have any legal right to see their grandchildren? I cannot answer this question as the law applies in every jurisdiction, but I can give you the answer as the law applies in Utah, which is where I practice divorce and family law, which includes a great deal of child custody and visitation law as well, and that includes grandparent visitation. As I've spoken to people over the course of my career, which is 25 years and counting as of the date I make this video, most people appear to be of the impression that grandparents either already have or should have rights to interact with their grandchildren and to have visitation. Now, by interaction, I mean personal visits with the children or remotely communicating with them, whether that be by telephone or video or in writing, a right to do those things. And I believe the reason most people feel this way is because most people have good feelings toward and good memories of their grandparents. And so they hastily believe that all grandparents are generally good and that all grandchildren would generally benefit from regular contact with their grandparents. But just as soon as people hear that expressed, they often realize the error in such thinking. They realize when reminded that not every grandparent is the kind of person who can and ought to interact with his or her grandchildren, because some people are dangerous to themselves or to others. Some people are bad examples. Some people are bad influences. Sometimes people were glad they finally got out from under their parents' thumbs, and they can't believe that now these people are asserting rights to see their grandchildren. In preparing for this video, I conducted some cursory research and found that all 50 states in the United States of America have grandparent visitation laws on the books, and Utah is no exception. Utah's original grandparent visitation law, which has since been amended, was originally found to be unconstitutional, an unconstitutional infringement of parental rights, to be exact. That case was Jones versus Jones in 2013 in the Utah Court of Appeals. The old version of the statute entitled, over the objection of the parents of the child, for grandparents to have a court order of grandchild visitation as long as the grandparent or grandparents met these requirements. And I'm quoting the old statute. Quote, there is a rebuttable presumption that a parent's decision with regard to grandparent visitation is in the grandchild's best interests. However, the court may override the parent's decision and grant the petitioner, meaning the grandparent, reasonable rights of visitation if the court finds that the petitioner has rebutted the presumption based upon factors which the court considers to be relevant, such as whether A, the petitioner is a fit and proper person to have visitation with the grandchild, B, visitation with the grandchild has been denied or unreasonably limited, C, the parent is unfit or incompetent, D, the petitioner has acted as the grandchild's custodian or caregiver or otherwise has had a substantial relationship with the grandchild, and the loss or cessation of that relationship is likely to cause harm to the grandchild. E, the petitioner's child, who is a parent of the grandchild, has died or become a non-custodial parent through divorce or legal separation. F, the petitioner's child, who is a parent of the grandchild, has been missing for an extended period of time. Or G, visitation is in the best interest of the grandchild. You can see how it'd be pretty hard not to get grandparent visitation under the old law. But the Court of Appeals in Jones versus Jones held that the problem with the original grandparent visitation rights statute was that it was unconstitutional. The Court of Appeals opined in paragraphs 24 and 25 of its decision, quote, the grandparent visitation statute qualifies as legislation infringing on parental rights in a substantial, not merely incidental way, because it allows the state to override a parent's decision regarding the care, custody, and control of her child. In this case, the parent that was being challenged was just a single widowed mother. The Court of Appeals cited certain cases both in Utah and from the U.S. Supreme Court, citing particularly Justice Souter, who concurred in a particular decision, noting that not every law that incidentally makes it somewhat harder to exercise a fundamental liberty must be justified by a compelling counter-interest, but only those laws that substantially infringe on a fundamental liberty interest. They also cited to Koshko versus Haining, a Maryland case, if I remember correctly, holding that the state's grandparent visitation statute infringed on a fundamental right in a direct and substantial way. Furthermore, the Court of Appeals went on, as noted above, the application of strict scrutiny is consistent with the majority of other jurisdictions to address the issue under the federal Constitution. We agree with the reasoning of those cases and thus conclude that strict scrutiny review applies to the mother's claim that the statute, the grandparent statute, visitation, as applied, violated her rights under the Utah and United States Constitution. Paragraph 25, Quote, as noted above, a statute that infringes upon a parent's fundamental right is subject to heightened scrutiny and is unconstitutional unless it, 1, furthers a compelling state interest, and 2, the means adopted are narrowly tailored to achieve the basic statutory purpose. That's quoting Jensen ex rel. Jensen versus Cunningham, a Utah Supreme Court from 2011, quoting the Wells case. The Court of Appeals went on. The grandparent visitation statute, as applied to the facts of this case, satisfies neither element of this test. Okay, I'm done quoting. So to remedy the unconstitutional defects in Utah's grandparent visitation rights statute, the defective part was amended to provide as follows. Quote, in accordance with section 80-2A201 of the Utah Code, it is the policy of this state that the fundamental right of a parent to exercise primary control over the care, supervision, upbringing, and education of the parent's children. B, a court shall presume that a parent's decision in regard to grandparent visitation is in the best interest of the parent's child. 3, a court may find the presumption of subsection 2b rebutted if the grandparent, by clear and convincing evidence, establishes that A, the grandparent has filled the role of custodian or caregiver to the grandchild, that Romanet 1 is in a manner akin to a parent, and Romanet 2, the loss of the relationship between the grandparent and the grandchild would cause substantial harm to the grandchild, or B, both parents are unfit or incompetent in a manner that causes potential harm to the grandchild. You see the difference? A lot more strict. The old statute was also amended to omit this provision of the old statute. 4, subject to the provision of subsections 2 and 3, the court may inquire of the grandchild and take into account the grandchild desires regarding visitation. So what does this mean for grandparents seeking visitation rights with their grandchildren in Utah today? To put it simply, it means that for grandparents to win a case seeking rights of visitation with their grandchildren, they can't merely show that it would be a good idea, or it merely in the child's best interest, or that the child would suffer major harm without visitation with the grandparents. The grandparents must show that either A, the grandparent has filled the role of a custodian or caregiver to the grandchild in a manner akin to a parent, and that the loss of the relationship between the grandparent and grandchild would cause the child substantial harm, or B, both parents are unfit or incompetent parents in a manner that causes potential harm to the grandchild. Merely showing it would be in the best interest of the child for the grandparents to have visitation with the grandchild is not enough to obtain a court order of grandparent visitation in Utah. Getting grandparent visitation is pretty hard for the average grandparent if the parents don't want it.